You're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I was afraid the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened and hopefully not engaged in the type of conduct that caused this to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was an unfortunate incident where, and I'm not contesting her culpability or her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously, if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address the court as well. Is that right? What do you have to say for yourself?
I do apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm really serious, and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full age.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail, and then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies, that ended up with you going to prison. 5 years it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, finds you guilty of robbery. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimmler.
Judge, I'm sorry to interrupt.
case number.
I did.
You went on the robbery and we actually entered the plea on the assault.
Sorry. 25 DCCR 0979
Right, that's the assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just said on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated. All
Okay.
right. And we have to have that discovery certification today because the case is going to get to close
Not
down.
again, you never gave it to me.
Well, I mean, when she first pled.
So do I?
You didn't give
You
it.
to give me a
Still got the credit for me being in here on this.
Yes. All the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. Good morning. Are you Lric Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct?
The judge wastes no time straight to the facts. A plea deal already rejected. That means the court isn't in a forgiving mood today.
So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because you know, on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it. And all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous, okay? All right, go back with the bailiff. I'll reset the case. Good morning. You're Lenton Arseno? And Mr. Arseno, are you currently sick?
Ma'am?
Are you sick right now?
No, ma'am.
Would you pull that down for me just so, there you go, I can hear you better in the hearing. And Mr. Arseno, in cause number 24, DCCR 2190, was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor. None from the defense.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time. The criminal trespasses that were all dismissed, all those. It looks, to defense lawyer, to me, it looks worse than it. I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got.
Notice how the defense tries to humanize her. She regrets it. She's learning classic strategy, but the judge's patience is running thin. Watch how he responds next.
The minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to the penitentiary. He stayed in the state. He stayed in county jail on that. That's my understanding, Judge. And I'm not making light.
On that case, he did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I bought everything in myself.
And I watched the interview, and it was confusing to me as to what he had to do. And I don't know. I think he probably just got frustrated and just didn't go the next time, next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to sentencing towards the lower end, Judge. I don't think 10 years, 10 years is a long time for him not reporting for that. So Judge, I would ask that you consider, he doesn't want a trial, he doesn't want probation. He said that he was upfront with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
Thank you. Mr.
I
Hoffpower?
want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version. I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge, and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at. And if you aren't, then you're supervising yourself, and that's the problem. So the only reason I think the state, and it's up to the court, obviously I don't agree with the lower end. I agree we have to know where he is, because if we allow him to do it, he ain't gonna come. And he's not gonna report, so we need to do the maximum of.
And here comes the hammer. The judge is about to walk us through her entire record. When a judge starts reading your past line by line, you know it's over.
10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffpower. So, Mr. Arseno, I noticed the same thing that Mr. Hoffpower did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part. You didn't say that?
No, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. When you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register. And you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I
sense.
went in front of Judge Stevenson. What is it?
No. You went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender.
Yes, ma'am.
So you did know you have to register, because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay. All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Boom, 8 years locked in, but wait a twist, even the judge messes up the charge. That's how packed this courtroom day is.
Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the...
And here we go again, another defendant, another tragic backstory. But this time failing to register as a sex offender is no small slip up. The courtroom's tone shifts from shock to disappointment.